I'm Valerie Powers-Smith, and today I want to talk about the overall topic of the importance of planning. In terms of planning, we're talking about two different categories. One is what I call incapacity planning, if anything happens during your lifetime, to make sure that you have someone appointed to be able to effectuate your wishes. Two documents that help in that are durable power of attorney and a healthcare directive. Healthcare directive can also be referred to as an advance directive or a living will. These two documents, if ever going to go into effect, will go into effect during your lifetime, and you appoint who can step into your shoes and make decisions in the case of the durable power of attorney, your financial or personal business matters, and in the case of the healthcare directive, accessing medical documents, making medical decisions, or speaking with your physicians. It's very important to have these documents, particularly if you're in a jurisdiction where conservatorship can be petitioned by a family member where they feel that you can no longer manage yourself or your affairs. If you have thought about this in incapacity planning type of documents, you can indicate if that would ever happen to you during your lifetime, who do you want to serve in that position? And that speaks volumes if a conservatorship petition was ever filed, that a judge can use that as a gauge. The other category of planning for your future is estate planning. Estate planning encompasses will, trust, and the other documents I've already discussed. Depending on your jurisdiction, your will may be the driving force of your estate plan, whereas in other jurisdictions, your trust may be the driving force. The reason why I make that distinction is because it depends on the state's probate laws as to whether or not it's an onerous process or an expensive process that you want to avoid by way of having all of your assets in a trust at the time of your death. Those documents allow you to pick certain fiduciary appointments. The executor is in charge of your will. That person marshals your assets, determines what debts you have, and determines who then gets your estate under your will as per your language in your will. The trustee is a similar role if you have a trust-driven estate plan in terms of marshaling the assets, figuring out your debts, and then distributing your assets under your trust as per your directions in terms of what individuals in your family, friends, or charities you would like to receive your estate. It's critically important that you have all four of these documents in place so that you are not left to the decisions of the state's intestacy laws, which that is what happens when someone dies either without any of these estate planning documents or if something within their estate plan fails. The laws of intestate will define who is in charge by way of relationship, and they will also define who gets your estate based on your relationship. And many individuals come into my office and say they don't like certain family members, so why not take the time and plan ahead so that you can have people you trust making decisions in your fiduciary roles and also receiving your estates.